Good evening, friends. Once again, I have come with another topic, and that is anti defection law. Anti defection law, which was passed in 1985, and it changed four articles: 103, 3A, 102 to 193 and 192. And it also added 10th schedule by 52nd Amendment 1985. The para, you will see that para 2 of the 10th schedule defines defection. What is defection? Suppose a person getting elected on a political party's symbol, after getting elected, he joins another party or abstains from voting voluntarily or crosses the floor, then he is liable to defection. हिंदी में समझिए, किसी भी इलेक्शन में कोई व्यक्ति किसी पॉलिटिकल पार्टीज के सिंबल पे चुनाव चिन्ह पर चुन करके आए और उसके बाद उस पार्टी के विपरीत किसी और पार्टी को ज्वाइन कर ले. Usually what happens that suppose the political party on whose symbol you have been elected is not able to form the government, then there is a horse trading and the crossing of floors becomes natural. Means it has become a natural phenomenon in our country, and therefore, in order to prevent this menace, because it is a complete undemocratic, or you can say that attacking the very root of democracy and violating the verdict, or you can say mandate of the people. People elected you because they accepted a particular manifesto exhibited and shown by the political party. And that's why when the political party enters into the fray, वो अपने अपने मैनिफेस्टो के साथ आते हैं. जो भी पॉलिटिकल पार्टीज होती हैं अपने अपने मैनिफेस्टो के साथ आते हैं कि हम चुने जाने के बाद, सरकार में आने के बाद ये चीजें करेंगे. इसलिए हर पॉलिटिकल पार्टी अपना एक मैनिफेस्टो करती है कि हमारा 5 साल में ये उद्देश्य होगा और हम इसको जो है अचीव करेंगे. इसके आधार पर लोगों को ये चॉइस होता है कि वो क्या चाहते हैं. वो ब्रिज चाहते हैं, हॉस्पिटल चाहते हैं, वो मुफ्त की शिक्षा चाहते हैं, मुफ्त का अनाज चाहते हैं, वो क्या चाहते हैं. ऑन दैट बेसिस, दैट मैनिफेस्टो, people elect their representative. Now, suppose that they have endorsed a certain manifesto and therefore elected a particular person from their constituency to go and represent, their will. But just after getting elected, what the person finds that his political party on whose symbol he was elected is not able or in a position to form the government because they are lacking the majority. In such a situation, suppose the opposition party started alluring or enticing other, members of the parliament so that they could garner sufficient vote to form the government. In such a situation, these defectors, it was very much prevalent in those days, and therefore, in order to protect the democracy, it was indispensable to bring certain laws so that these defectors could be prevented. So 52nd Amendment 1985 added 10th schedule, and 10th schedule para second defines it that any person elected on a political party symbol after getting elected, if he abstains from voting or crossing the floor deliberately, voluntarily, he is liable to be defective, disqualification, because he has committed the defection. Now, because of this problem, in 52nd Amendment, when 10th schedule was added, so it has the capacity, it also changed four articles. And it also understood that who is going to decide. Now, you see, who is final authority to take a decision on disqualification? It is the speaker or the chairman of the house. They are going to take a final call. Now, everybody knows that they are political creatures. And therefore, in the 52nd Amendment, what happened that they said that, see, only they are going to take a call, but the speaker's order will not be challenged in any court. Means, see, it is para 7 of the 10th schedule. It excluded the jurisdiction of the court, but Supreme Court, in which govern Kiloton, Quijota Holohon versus Zakilu in 1992, in a judgment, the Supreme Court held that since this 10th schedule, they are ousting the jurisdiction of the courts, but they are also encroaching and they are changing the federal structure. You know it very well. There are three ways by which the constitution can be amended: one by simple majority, second by a special majority, and third, special majority with ratification of at least half of the state legislature. So, under 368 clause 2, it is encroaching upon the rights of the judicial review. And since it is not only hitting upon 137, then see, I have already written over here that it is 136, 226, and 227. Therefore, those provisions which are going to change the federal structure are liable to be ratified by at least half of the states, and therefore it is not happening. And you cannot oust, you cannot exclude the judicial review. Therefore, it was held in this judgment that Supreme Court exercised judicial review on the speaker's order. Now, you come another point, that 91st Amendment Act 2003. 91st Amendment, the original 52nd Amendment, at that time it was in the original bill. At that time it was there that if one third of the member of that political party on which whose symbol they were elected, after that, if one third members split the party and joins, then that was allowed. But 52nd Amendment, sorry, 91st Amendment omitted the entire section in which it was written that one third member, if they are split from the original political party and joins another party, that was not deemed to be defection. But at the same time, it also mentioned that if the two-third members of the party, but not less than two-third members of the political party on whose symbol these members were elected, if they chose to join collectively or merge their party with another, and that was allowed, and that is still allowed. Now we know, see, that the incident in the Manipur, what happened, that the speaker disqualified several MLAs, and this was challenged in the court, and the court said that his order of disqualifying was subject to judicial review. But the speaker said that no, I'm immune from the judicial review. The Supreme Court also ordered for the contempt of the court, but still he was defying the order of the Supreme Court and not appearing before the court. Therefore, the Supreme Court again ordered that even if a little bit force is required, he must be brought before the court. Eventually, the government brought the speaker before the court and the charges were dropped. But we have to understand that speaker is the post usually elected by the political party. So their allegiance towards the political party or the majority, which is the incumbent government, cannot be ruled out. So usually what happens that they always act in the whims and fancy of the government. They are not neutral. हिंदी में हम समझें कि स्पीकर जो है, चूंकि पॉलिटिकल पार्टी जो मेजोरिटी में होती है, जिसकी गवर्नमेंट होती है, उसी का लगभग जो है स्पीकर होता है, और स्पीकर जो है, जो उसका लॉयल्टी होता है उस पार्टी के द्वारा, वो टूट नहीं पाता है, क्योंकि अभी भी वो मेंबर ही होता है। और इसकी वजह से चुने जाने के बाद भी अक्सर करके वह वही कार्य करता है जो उस पॉलिटिकल पार्टी के फेवर में हो, जिस पॉलिटिकल पार्टी का वह मेंबर है। तो वह न्यूट्रल ना होकर के कई बार वह डिसाइड करता है विदाउट इवन टेकिंग इनटू कॉन्फिडेंस, विदाउट इवन गिविंग द अपॉर्चुनिटी टू द एमएलए टू रिप्रेजेंट हिमसेल्फ, यानी नेचुरल जस्टिस का कंप्लीट वायलेशन होता है। एंड देयरफॉर इवन टिल टुडे there has been several instances in Goa or in Uttar Pradesh, in Manipur, several states कि जो स्पीकर होता है वो अपने पॉलिटिकल जो मास्टर्स हैं, जिनका वो भी मेंबर है, उसके आधार पर वह एक्शन लेता है। और इसलिए बीइंग अ पॉलिटिकल क्रीचर, हिज ऑर्डर is subject to judicial review. That is fine. There has been several occasions in the Supreme Court had to intervene, and the order of the speaker was set aside by the court because of the violation of natural justice. तो हम देखते हैं कि ये एंटी डिफेक्शन लॉ, why was it necessary? Because it was hitting at the very root of the democracy. It is very undemocratic that you are violating the mandate of the people. People elected you because they thought that you are going to represent their people, and they are endorsing the manifesto of a political party, but after getting elected. Now, see, there are two ways by which you can give up the membership of the political party. One is, suppose that after being elected, you are not satisfied with the policies or attitude of the government, that these policies are not in favor of the electorate which I'm representing, and despite, or suppose that sometimes your views are not taken and you are snubbed, ऐसी भी सिचुएशन में क्या होता है कि you can resign and then you can go for the fresh election. But if being the member of the political party, you cross the floor, then that is defection. So just summarize. Let us summarize that anti-defection law was brought by the 52nd Amendment 1985 to curb the menace of defection. But at that time, it was written that one third members of the party, if split from the original party, that cannot be taken as a defection. But once again, this was also rectified by 91st Amendment, 2003, in which it was entire that para was omitted, and now only the portion is that two-third. If two-third members from that original party merge themselves into another political party, then that will not be taken as affection. But even today, we know it very well that these things are happening, and the speaker, who is the ultimate authority to take a decision in this regard, earlier his this was jurisdiction of the Supreme Court and High Court was taken out from the purview. But in this judgment, you know, Quijota Holon versus Jekyll in 1992, the majority bench, means 3 is to 2, the Supreme Court held that you cannot oust the judicial review unless it is ratified under Article 362(2) by at least half of the state legislatures. So that's it for today. I hope that you have understood the concept of anti defection, the objective behind the anti इसके पीछे जो उद्देश्य क्या था, कहाँ तक हम इसको रोक पाए हैं, क्या सही में स्पीकर और चेयरमैन इन चीजों को रोक पाए हैं, क्या वो सही में अनबायस्ड होकर के निर्णय ले पाए हैं. I think that we must agree to disagree on this point, but at the same time we must be unanimous in one regard, that we have not been able to curb the this menace of horse trading and anti-defection, because we have witnessed wad of notes being waved inside the parliament. So let us hope that the strict laws are made, and some agencies are also given. For example, this there must be independent agency which inquire into it, and if they give a decision after having the evidence and everything, then it must be decided by the speaker, or by the uh, chairman, and they must be bound by the decision given by the independent agency, rather than right now they are taking the decision at the whims and fancy of the political party which they represent. So that's it for today. Thank you very much for listening and watching my channel.